In this episode, I would like to discuss about one important section of the Indian Contract Act 1872, that is section 11, which says that who are competent to contract. That means what is the competency for entering into a contract, or otherwise it can be said that whether a minor person can enter into the contract. That is the topic of discussion today. According to section 11 of the Indian Contract Act, in order to become the competent party to enter into the contract, the two conditions are to be satisfied. That means the parties must be mature and having the sound mind. So the persons who are mature and having the sound mindedness, they are entitled to enter into a contract in pursuance of the Indian Contract Act 1872. Now let us consider that what is the majority, what is the age of majority. So age of majority means if any person has attained the age of 18 years. So if any person has entered into the 18 years, he can enter into the contract. But if any guardian is appointed by the court, in that case the majority age is 21 years. So if any person's guardian is appointed by the court, then 21 years will be considered as the age of majority. Otherwise, in ordinary cases, 18 years is the age of majority, that means the competency, and it is in pursuance of also the Indian Majority Act. According to Indian Majority Act also, 18 years is the term for becoming the major. So according to the Indian Contract Act, the person who has attained the age of 18 years is competent to contract, but if his guardian is appointed by the court, then 21 years is considered as age of majority. First of all, I would like to discuss about one landmark judgment of the Privy Council in the year 1903, that is Muhari Bibi versus Dharmadas Ghosh. In this case, it was decided by the Privy Council that minor's agreement is absolutely void. So if any agreement is entered by a minor, according to this judgment, the agreement is void and no right can be agitated about this agreement. Now what happened in this case in a brief manner, that is the minor borrowed the money by mortgaging his property. It was decided that mortgagee cannot exercise his right against the minor for securing the loan amount, because the agreement is void in pursuance of the Contract Act. So in this case, it was decided by the Privy Council that the minor's agreement is absolutely void, but some additional points were discussed by the court. That means a minor can exercise his right against the other person, but no other person can exercise his right against the minor. That means minor has the right, but minor has no obligations in any contract. So the agreement is, if it is void, if the agreement is void, then minor and other persons both cannot have any right. But if the agreement is voidable, then minor has the right to exercise his right, to enforce his right against the other, but other person has no right against the minor or against his property. So minor is entitled to get the benefit, but minor has no obligation, neither minor's property has any obligation if the agreement is void. And another thing, that minor cannot ratify such agreement after attaining the age of majority. So after becoming major, that means 18 years when he has attained, or in case of guardian appointed by the court after attaining the age of 21 years, minor cannot ratify it, that means sanction it, because it was void ab initio. So that's why ratification is also not allowed. Now I would like to discuss about the second case, that is Mir Sarwarjan versus Fakhruddin Muhammad Chaudhuri. In this case, in the year 1912, it was decided that the agreement cannot be made by the guardian on behalf of the minor. So, what happened in this case in a brief manner, that the guardian of minor entered into an agreement to purchase one immovable property for the minor, and minor later on filed the suit for specific performance of the contract, but it was decided that minor cannot enforce such agreement because it was entered into on behalf of him by his guardian. So, that is why the suit of specific performance was not allowed. So, it was decided by the court that since minor is absolutely barred to enter into the contract, so no agreement on behalf of the minor can be entered into by his guardian on his behalf. Now, I would like to discuss about the third case, that is Srikakulam Subramaniam versus Kurra Subba Rao. In this case, it was decided by the court that agreement can be made for the benefit of the minor by his guardian. So, what happened in this case in a brief manner, that father made the mortgage and secured the loan amount, and ultimately mother sold out the property to satisfy the debt of the father, that means reimbursement of the debt. Mother entered into the contract to sell out the property of immovable property stands in the name of the minor, and it was decided by the court that yes, mother can enter into the contract in order to sell out the property on behalf of the minor in order to reimburse the debt, mortgage debt made by the father. So, ultimately in this judgment, the earlier decision of Mir Sarwarjan was deleted. So, that means this judgment reverts the order of the Mir Sarwarjan, and ultimately now agreement can be entered by the guardian on behalf of the minor if it is made for his benefit. So, now let us have a look what I have already discussed, that is according to the Indian Contract Act 1872 section 11, that who are competent to contract, two conditions of competency, that is majority and soundness of mind, or can a minor enter into a contract. So, cases I have already discussed. First is Muhari Bibi versus Dharmadas Ghosh 1903 Cal Privy Council judgment. Next is Mir Sarwarjan versus Fakhruddin Muhammad Chaudhuri 1912, and number 3 Srikakulam Subramaniam versus Kurra Subba Rao AIR 1948. Now, I would like to discuss about the effects of minor's agreement. Now, first point is no estoppel against the minor. We know that section 115 of the Indian Evidence Act deals with the doctrine of estoppel, but that is not applied if the agreement is entered upon by the minor. So, that means minor though have entered into the agreement, but still the doctrine of estoppel is not applicable against him. That means he can take the plea that he was minor at the time of entering into the contract. So, infant or minor is not stopped from setting up the infancy or minority as a way of defense. So, though minor has entered into the agreement, but still he is not stopped from claiming the infancy or minority as a way of defense. Now, second effect is that no legal liability in contract or tort arising out of any contract entered by the minor. So, if any agreement is entered by the minor, there is no contractual or tortious liability. So, minor's agreement is always devoid of all legal effects, and since it is void ab initio, means from the very beginning it is void. So, no liability will ensue upon this agreement. So, there is no obligation relating to the agreement entered by the minor, but there is the right accrues, but no liability or obligation ensues. Though the obligation or liability will not ensue upon any agreement entered into by any minor, but still minor is entitled to get the right, or minor can exercise his right against any agreement. So, right of the minor accrues though the agreement is void. Now, next point is, that is doctrine of restitution or equitable doctrine of restitution. It means that though the agreement of minor is void, but minor can be compelled to restore the property so long it is traceable in his possession. So, if the property is traceable, then he is bound to restore it, he can be compelled to restore it. So, let us have a look that no estoppel against the minor. We are considering the effects of minor's agreement. Now, first is no estoppel against the minor, as I have already discussed. Next is no liability of minor in contract or tort arising out of the contract. Number 3, right of minor is accrued in contract but devoid of any obligation. And 4th, equitable doctrine of restitution. Now, I would like to discuss about the next legal effect of the minor's agreement, that is minor seeking the relief is compellable to restore the benefits or suitable compensation to the other party. So, if the agreement is entered by any minor and minor is seeking the relief on the basis of the agreement, then he is compelled to restore the benefits what he has secured from the agreement. Next point is, that is what is the effect on marriage contract entered by the minor. So, if any contract of marriage is entered by a minor, so minor can enforce such agreement, but minor cannot be enforced, it cannot be enforced against him. So, that means if any matrimonial agreement is entered upon by the minor, minor has got the right to enforce it, but minor has no obligation. No other person can enforce against the minor. And then contract of apprenticeship, that means if the agreement is made by the guardian on behalf of the minor in pursuance of the Apprenticeship Act, the agreement is valid. Next point is, that is liability for necessaries. So, if any minor is supplied with some essential commodities which is necessary for his life, in emergency situation it was provided to him for his subsistence, the minor's guardian is bound to make the payment, he is bound to reimburse such costs. That means minor's property is also responsible to make the payment. That means obligation of the services rendered, minor's estate or estate of the infant is bound, because the amount can be recovered against the property of the minor, and that is by virtue of section 68 of the Indian Contract Act, which says that about a kind of quasi contract. Quasi means semi or alike. So, it is a kind of quasi contract by virtue of section 68, that if any minor is supplied with some essential commodities, then his legal guardian is bound to reimburse, and also his property is also bound. That means the money can be recovered from minor's property. So, let us have a look what point I have discussed right now, that is next is minors seeking the relief compellable to restore the benefits or suitable compensation to other party, and contract of marriage, contract of apprenticeship and liability for necessaries. Now, I would like to discuss the next important point, that is effect of ratification. That means whether a minor can ratify any agreement entered upon by him during his minority. No, because he cannot ratify it, because the agreement actually relates back to the date of making the contract, and so contract then was void, since it is void ab initio, means from the very beginning it is void. So, as it is void ab initio, that is why it cannot be validated by subsequent ratification by the minor. So, if the minor wants to validate the agreement which was entered upon by him during his minority, the fresh contract is to be made. Earlier contract cannot be ratified in this way, fresh agreement is to be made. And one judgment is there, that is Suraj Narayan versus Sukur Ahir. It was decided that agreement cannot be ratified in this way. The brief manner of the case is that a minor borrowed a sum of money executing a simple bond, and after attaining the majority he executed a second bond in respect of the original loan and as well as interest. But court decided that suit upon the second bond was not maintainable. So, let us have a look regarding this point, that is ratification. Minor cannot ratify and fresh contract is to be made, and the case reference as I have cited, that is Suraj Narayan versus Suku Ahir, where it was decided by the court that minor cannot ratify in this way, fresh agreement is necessary to be made. Last point is, that is minor's position as a partner in a partnership firm. According to section 30 of the Indian Partnership Act 1932, there are some conditions in case any minor is a partner in a partnership firm. So, by virtue of section 30 of the Indian Partnership Act 1932, minor cannot be considered as a full-fledged partner. Minor cannot be a partner in a partnership firm, though minor can be admitted as a beneficiary to the share of profits of the partnership firm. So, minor though cannot be a partner in a partnership firm, but minor can be admitted as a beneficiary of the profits of partnership firm, and minor can get only the share of profit. He is entitled to receive the share of profit, but he is not incurring any liability in case of the loss. So, if there is any loss sustained by the partnership firm during conduct of the business of the firm, minor is entitled to the share of the profit, but is not incurring any liability in case of the loss. And moreover, partner has no personal liability in case of any loss of the partnership firm, or if there is any market debts. That means minor is not liable in case of loss or in case of debts of the partnership firm, but minor's profit and minor's property or assets of the firm is liable to satisfy the demands of the creditors against the partnership firm. So, only the profit of the partnership firm and his assets in the partnership firm is liable to make payment of the demand of the creditors, but minor is not personally liable in any case. So, let us have a look that means minor's position as a partner. Section 30 of the Indian Partnership Act 1932, as I have said, that minor cannot be a partner of the firm, but minor can be admitted to the benefits of the partnership firm. Number 3, minor can get share of the profit Fourth, minor cannot incur personal liability in loss or in debt of the firm. And finally, minor's property and profits of the partnership firm is only liable to pay off the liabilities of the firm. So, these are the essential points highlighted in section 30 of the Partnership Act. Now, I would like to discuss about one decisions of our apex court, Supreme Court, that is CIT versus Shah Mohandas Sadhuram, AIR 1966. So, in this case CIT versus Shah Mohandas Sadhuram, it was decided by our apex court that minor can be admitted as a beneficiary to the partnership agreement, partnership firm. So, minor can be admitted to the benefits of the partnership firm, but only with consent of all the partners. So, if all the partners give the consent, then only minor can be admitted as a beneficiary in the partnership firm, otherwise not. And third point was decided that minor though can be admitted as a beneficiary, but under no circumstances minor can be considered as a full-fledged partner in a partnership firm. So, let us have a look that in case of CIT versus Shah Mohandas Sadhuram, AIR 1966, Supreme Court stated that minor can be admitted to the benefits of the partnership firm, but only with consent of all the partners and non full-fledged partner, and if then it is void agreement. So, if the agreement is made where a person though minor becomes the full-fledged partner, then the agreement will be void. So, what appears to us that according to section 11, the age of majority is sine qua non, that means the most indispensable thing in order to validate the contract. So, if the parties are not major, then agreement is void, but there are some exceptions where though the persons are minor, but by force of law they can enter into the contract. That means minor agreement is void, but not absolutely void. Because of some sections, partly minor's agreement is valid if those are prescribed by the law.